We are rewinding. Okay, everyone, welcome to our second panel of the day. My name is Kate Shaw. I teach at Cardozo Law School in New York City. I'll be, thank you, the moderator of our second panel. So the topic of the second panel is regulating people, places, and products. And obviously, a lot of the most pressing questions about gun regulation involve interactions between the Second Amendment and various efforts to regulate, right, people and places and products. So as the first panel alluded to, Heller suggests in one of its most famous paragraphs that certain kinds of regulations of some people and some places and some products are presumptively permissible. But what it says about those things is cursory, and it is subject to interpretation, and it is very much being contested right now. So this panel is going to dive into various dimensions of those questions. So our panelists are going to speak in the order in which we're sitting, and I'm just going to very briefly introduce the three. So Brannon Denning first teaches at Cumberland Law School at Samford University, writes broadly in constitutional law, including the Second Amendment, has published in lots of top law reviews, and written several books, most recently Guns and the Law, Cases, Materials, and Explanations. Next, we're going to hear from Bob Spitzer, who's the Distinguished Service Professor and Chair of the Political Science Department at SUNY Cortland, the author of literally hundreds of articles and 15 books on a number of subjects, including on guns, including most recently Guns Across America, Reconciling Gun Rules and Gun Rights. And finally, we'll hear from Jake Charles, who's the founding executive director of the Center for Firearms Law, the person responsible for putting today together. He's a graduate of Duke Law School, a former clerk in the Southern District of New York and the Fourth Circuit, and practiced at several law firms before, I guess, returning to Duke. So I will just turn it over now and mostly get out of the way.
Thank you. Thanks, Kate. Thanks to Joseph and Daryl and to Jake for the kind invitation. I say at the beginning that I'm so glad that Mary Ann confessed that she had not done her homework either. And so it lets me feel just marginally less guilty about such a tardy repayment on the hospitality and invitation. Nevertheless, I do have sort of an idea of what I'm working towards. And the title of my paper is going to be called, With Apologies to Richard Boone, which is a reference that only people of a certain age may know. Have gun, period, will travel, question mark. And it was spawned by, thank you for the delayed laughter, like my class. So it was inspired by a case that the Supreme Court, at least for now, is going to hear next term called it's called New York State Pistol and Rifle Association versus New York. And I want to talk a little bit about the case and the Second Circuit's decision, which had rejected a number of constitutional challenges to a New York City rule. And then try to, originally I was going to say something very jejune about, critiquing the Second Circuit's analysis. And while I was thinking about it, and it had been a very, sort of workaday critique of the underlying decision. And instead, when I was reading something completely different, it struck me that there was a different angle that one could bring to bear on not only this case, which for reasons I'll explain is likely never to see the light of day because it's probably moot now. But I think it does shed, or it has the possibility of shedding some light on a particularly troubling aspect, which we're addressing here broadly today, which is whether and to what extent the Second Amendment and gun rights extends outside the core identified by Heller and extends out into the public, and if so, how far and how robustly. And so I'm hoping that where I ended up after, giving this some thought is somewhere a little bit more interesting than where I was going to land before. So here we go. New York State Rifle and Pistol Association involved a New York City, it was really a rule, a police department rule, that interpreted the sort of scope of what were called licensed premises. As you probably know, it's very hard to get a license for a firearm in New York State, generally, or New York City in particular. In general, the state defers to localities. They're always, New York is a may-issue state, so if you want any kind of firearms permit, the local law enforcement has a great deal of discretion whether or not to give you one. The hardest, of course, to get in New York City are concealed carry permits. Not quite as difficult, but still not easy either, is a so-called premises license, which allows you to keep a firearm, which is defined as, I believe, a pistol, revolver, or certain kinds of rifles and shotguns of a particular length. And it's associated with a single address. Now, until recently, if you wanted to take that firearm to a shooting range or engage in a shooting competition, you could unload it, put it in a locked container, separate the firearm and the ammunition, and then you could go, say, to Connecticut, or you could go to upstate New York and go to a shooting range or engage in shooting competitions, whatever. Allegedly, and the extent to which this problem was a serious one, we don't know. Allegedly, the police began to report they would catch people, really with firearms either not properly stored or where they were carrying them nowhere near a shooting range or where nobody knew there was a shooting range. And so they basically changed the rule to say, all right, if you have a premises license for a New York City address, you can only visit shooting ranges within the 5 boroughs, basically within the city limits. And apparently there are like 11 or so. So it's possible, But if you wanted to go to a shooting competition and take your own firearms, which, it's understandable about why people would want to do that as opposed to using somebody else's, you couldn't. If you wanted to take your licensed firearm to your second home, say, in the Hudson Valley or whatever, or Westchester, or wherever, you couldn't because you would be leaving the 5 boroughs. So a number of plaintiffs, I think there were 4, 3 of whom wished to transport their guns for inter- and intra-state shooting competitions or to take them to particular ranges. One person also was a second homeowner, wished to transport his weapon to his second home and was unable to do so. They sued. And there was some sort of extraordinary machinations on New York City's part to try to get the case thrown out. They first started an administrative proceeding to alter the rule. They filed papers with the U.S. Supreme Court after the court had granted cert saying, please delay briefing. There's a chance that this will all change. And of course, I somehow missed this, but as Jake helpfully informed me last night, New York State actually changed the law, what was it, this summer, in order to basically say, basically return it, I think, to the old rule where you could take it as long as it was disassembled and you could take it outside the city limits. So, really my talk ought to stop here, I suppose. I have nothing more to say about a case. It's not going to be interesting, but I'll press on. I'll persist. The Second Circuit, so the plaintiffs brought 4 constitutional claims. They brought a Second Amendment claim. They brought a Dormant Commerce Clause claim. They brought a right to travel claim. And then they also brought a First Amendment freedom of association claim. The Supreme Court granted cert only on the first 3. And the Second Circuit's analysis did something probably that you would fully expect it to do. It had a section on the Second Amendment. It had a section on the Dormant Commerce Clause. And then it had a section on the right to travel as well as on the First Amendment. So it treated each one of those constitutional claims discretely. The Second Amendment, it applied the Second Circuit's version of intermediate scrutiny. It sort of assumed, for the sake of argument, that there were some aspects of the Second Amendment close enough to the core that application of intermediate scrutiny was warranted. It said, of course, a protection of health and safety, which is the justification that New York offered for the rule, excuse me, was an important governmental interest. Indeed, it said it's compelling, which is hard to argue with. And then it said, and we think that it's a substantial enough relationship. Really what they did was they sort of said, well, plaintiffs haven't demonstrated, which is sort of an odd odd little bit of burden shifting. It said the plaintiffs really haven't demonstrated that there's any serious interference with their right to keep and bear arms. They're free to, apply for another premises license in the case of the homeowner. Nothing is preventing the other plaintiffs from traveling to use guns for target shooting or for practicing, even assuming those are kind of penumbral Second Amendment rights, as cases from the Seventh Circuit have suggested. And we just don't think that there's very much of any kind of burden is minimal and probably incidental. As for the Dormant Commerce Clause claim, and this is, Dormant Commerce Clause is probably the other passion that I have in addition to the Second Amendment. Even I, as much as I love the Dormant Commerce Clause, it was a pretty weak claim to begin with. There was nothing in the record to suggest that New York City had passed this as a kind of sop to city-based firing ranges or otherwise to try to enrich the shooting ranges of New York. They would probably like to get rid of the shooting ranges that exist in the 5 boroughs if they could, but case law suggests that they cannot. And then finally, on the right to travel, this was very interesting because the Second Circuit articulated a pretty narrow version of the right. So it said, well, the right to travel constitutionally is only implicated if you're actually deterring people from traveling, if you're penalizing them for engaging in interstate travel, or if the law was intended to do any of those things. And as I'll talk about in a second, the right, as recognized by the U.S. Supreme Court, is a little bit more robust than that. And the case law suggests a little bit broader right, and that'll become important in a minute. And I thought it particularly curious that the court only cited, the Second Circuit only cited one U.S. Supreme Court right to travel case. The rest of the cases it cited were its own Second Circuit cases, and it ignored, some of the most recent right to travel cases that the Supreme Court has handed down. So, I think I'll skip. In the paper, I'm going to talk about why I think that even, the sort of disaggregated analysis that the court engaged in was weak in some important areas. But I'm going to put that to the side because I want to, talk about what I think is the more interesting, I hope, the more interesting angle to take on this, and that's to look at this case as one involving hybrid rights. So when we last saw hybrid rights, they were featured in Justice Scalia's majority opinion in Employment Division versus Smith. Scalia was explaining why generally applicable laws that incidentally burden religious observance are subject only to the rational basis test when you had a number of cases, Yoder, for example, involving the Amish and school attendance laws, Pierce, Myers and Pierce, which had sort of, religious overtones, kind of. You had cases like Sherbert versus Werner, in which, unemployment compensation was held to have been unconstitutionally denied to a Sabbatarian who refused to work on Saturday. And Scalia said, well, look, those cases this is not a quote-unquote hybrid rights case. Those involved other constitutional interests other than free exercise, including the right to raise your children or, the right to free speech. He talked about West Virginia Board of Education versus Barnett. And a lot of people at the time, and I think I was one of them, thought, well, that was sort of a make-weight argument. It just seemed like he was trying to dispense with some really inconvenient case law in order to articulate a brand new rule, but without, with sort of a, genuflecting to stare decisis. I've decided, after reading some of the literature about hybrid rights, I've decided that I was probably too hasty to write it off. It seems like that once you begin looking, you see hybrid rights or other types of constitutional combinations everywhere. It doesn't have to just be hybrid rights. You can have, if you think about McCulloch v. Maryland, you have power cases, right? You combine a Article I power with the necessary and proper clause, and you get a result that might not have been possible under either independently. And, most recently, hybrid rights sort of made an appearance in Obergefell, right? It's unclear how the alloy quite works, but the court quite clearly thought that there was an interaction between the due process and equal protection clauses in that case. And that maybe even if the due process clause on the one hand standing alone or the equal protection clause standing alone wouldn't have produced the results that came about, I'm skeptical, but anyway, but assuming it didn't, certainly the court's, Justice Kennedy's majority opinion says the two working in tandem made the result almost inevitable. And so, I think that those right combinations, feature in a lot of areas of constitutional law, and that we ought to maybe take those a little bit more seriously and try to see, the part that's under theorized is when you combine, and I'll bracket that for a second, but let me make the case that I think that a case such as the New York case furnishes an opportunity to consider how the Second Amendment on the one hand and the right to travel, which itself is a hybrid right, on the other, interact, and whether that interaction wouldn't at least require the state to produce much more evidence than they did, that the rule in place was necessary to protect the public health and safety. Let me back up just a second. I said the right to travel itself is a hybrid right, and it is. John Hart Ely once said that the court historically has been almost smug in its reluctance to root the right in a particular constitutional provision. And indeed, the court mentions several in the course of its different cases. And in some sense, this is because the right to travel itself is a kind of, has many facets, right? There's the right to ingress and egress. There's a right to interstate mobility. There's the right to travel in foreign commerce. And there's also the right to be treated once you enter a state as a friendly visitor, not an unwelcome alien. And when you establish residency, you immediately have equal rights with long-time residents. You can't discriminate on the basis on the length of residency in those cases. So those different facets of the right have been attributed variously to the Commerce Clause, and particularly the Dormant Commerce Clause, the inability of states to limit the movement of persons and things in interstate commerce. The Privileges and Immunities Clause of Article 4, right? Section 2, that's the one that says citizens of a state shall have the privileges and immunities of citizens of the several states. The Equal Protection Clause. In fact, there are a number of cases from the 70s and early 80s in which the right to travel and the Equal Protection Clause work in tandem to invalidate restrictions, for example, on newcomers receiving various kinds of welfare benefits or other state sort of benefits. The nature of the union. I mean, early cases just sort of said, look, the right to move about in this country is just, it's part and parcel of the fact that we're one nation and not, a kind of loose confederation. And then finally, most recently, in 1999, there was a case called Saines v. Roe, where the court said, look, the right to enter a state and begin enjoying benefits on terms of with longtime residents is it's a privilege or immunity of national citizenship, and pointed towards the Privileges or Immunities Clause of the 14th Amendment as a source. Well, however you want to, wherever you want to ground it, and some aspects of the right to travel, I think, are grounded better in some clauses than others. But my point simply is that the court often, when it talks about the right to travel, it will cite all of these and say all of these work in tandem to support the notion that we have the right to move about freely, and that state laws that deter that even, I mean, forget penalize, if it just deters that interstate travel, the state has to justify And the court is sort of cagey sometimes. Sometimes it uses strict scrutiny. Sometimes it'll sort of say, well, it isn't even rational to make these kinds of distinctions, when really they're not really applying a kind of deferential rational basis test. They're doing something a little bit different. So should it matter that this case, the New York case, involves both the Second Amendment, insofar as the Second Amendment does have these sort of core rights to protect oneself and one's home, at least as to the person with the second home, or that it has these penumbral rights, which the Second Amendment, the Seventh Circuit has recognized that part and parcel of exercising your Second Amendment right includes the right to obtain and maintain proficiency in the use of the arm, practice with it. You would think that you would want, the people who chose to own guns to at least know how to use them safely and accurately. That should it matter that those aspects of the Second Amendment are involved, plus the right to travel is involved. And I would say yes. I think that the two in combination should require, and I'll argue this, at a little more length in the paper, I think it should have triggered a responsibility of the city to demonstrate something more than it did to justify the maintenance of the rule. I think that just sort of gesturing towards, what Holmes called the convenient apologetics of the police power, and then put the burden on the plaintiffs to demonstrate exactly how their right had been burdened and how, or to what extent their right had been burdened, I think it's like looking through the wrong end of the telescope. And I think that looking at this as a hybrid rights case might make it a little easier to shift that burden back where it belongs, which I think is on the state, and at least require the city to come up with something a little more concrete than an affidavit of the former licensing officer who says, yeah, there were these problems. It just seemed, it's, just more, a cop's got a lot to do. We can't be checking everybody's premises license, making sure that they're, where they're supposed to be and that they've complied with all the regulations. I just think that doesn't comport with, what it means to have a right. And even if the right to travel itself and the Second Amendment independently wouldn't produce the result, I think the two in tandem in this case does. Now, let me make one important qualification. and I think that this is, I want to try to be appropriately modest in my claim. I'm not sure that I would be willing to jump from this case, traveling from point A to point B with a license, in order to get to a shooting competition or go to a shooting range of my choice. I wouldn't be willing to jump from there to saying that this hybrid right idea has a whole lot to say about the concealed carry debate. I'd have to think more about that, but I'm not sure that I would be willing to make that step, in large part because I think the right to travel and all that has sort of existed alongside regulations of concealed carry just as an historical matter. But again, I could be persuaded. But I think I'll stop there. I look forward to your questions, and I look forward to hearing from my other panelists.
Mr. DeMille?
I wonder if we're going to be in the way at all. We'll see how far it goes down. No.
Suddenly this room feels a little bit like an air raid shelter, doesn't it? Is this amplified here? Can you hear me standing over here? Okay. All right.
Suspense.
Okay then. The movie will start in 12 seconds.
It's going to be worth it when we get to zero.
I think we're showing the 10 Commandments. Directed by Cecil B. DeMille, by the way. Yeah, there we are. I'm always so grateful when these things work, you know. Good morning. Pleasure to be here. Thanks to our organizers and hosts. So this is my paper. That's the title of the paper. Pretty descriptive. To Mr. DeMille, can you put that on the side screen too that you suggested to me? Just so, like if you're sitting there, you could, he said he could put it over, maybe not. Okay, it's fine. It's fine. Don't worry about it. All right. Okay, so gun accessories. Oh, well, that worked. Oh, here we are. Okay. And this is a fairly brief summary of my paper. There are things that I'm leaving out from the presentation. So there's a new wrinkle to the Second Amendment debate. That is to say, are gun accessories protected? And this might not seem like a real thing to some, but in fact, recent legal arguments have been advanced to provide Second Amendment protections for ammunition magazines and gun silencers. And on the left in the bottom there, that's a 100-round drum magazine, which was used by the, not that actual one, but was used by the mass shooter in Ohio not very long ago. So in the case of Duncan versus Becerra there, a federal judge struck down California's longstanding 10-round magazine limit. It had been in California law since, I think, the end of the 1990s, arguing that owning a large capacity magazine, LCM, is a core Second Amendment right. And the judge used that term, a core right, 3 times in the decision, as if to emphasize that it's not only within the Second Amendment, but it's central to the Second Amendment. That case is on appeal to the Ninth Circuit, and we'll see what the Ninth Circuit has to say about it. In a different case, U.S. versus Cox, the 10th Circuit Court of Appeals rejected an argument before them that gun silencers were protected under the Second Amendment. That case was appealed to the Supreme Court. The Supreme Court decided not to hear the case, but the fact is this case existed, was floating around, making this argument. And this is in the context of some other things that are going on, because these arguments have been advanced under sort of some particular circumstances. Lower federal courts and the Supreme Court are ever more conservative. President Trump has appointed, and with great speed, a great many conservative judges since he's been in office. And pretty clearly, these are judges who have a thorough Second Amendment gun rights fealty. It's almost unimaginable that the Trump administration would appoint somebody who did not have this loyalty. There is a growing sentiment among some that, in the words of Clarence Thomas, as he said in 2018, that the Second Amendment has been treated cavalierly, as a disfavored right, and as a constitutional orphan. These are comments that he made in a dissenting opinion. And apropos of Brannon's paper, and I would emphasize, Brannon, you should stick with that case, because it's not so clear that it's going to be a dead end. Because as you may know, I think it's next week the Supreme Court is going to hear oral arguments on whether to take the case, even though it seems indisputably mooted, because New York City repealed the rule that was the basis for this case. But it also raises the question of why did the court agree to hear that particular challenge? It's been now 10 years since Heller. And because it's really this sort of obscure rule, and Brannon described it very nicely. Of all of the various appeals to various gun laws that the court has decided not to hear, why would they accept this kind of obscure, a challenge to this obscure rule that probably only New York City out of the entire country has? And there's reason to believe they wanted to hear it to expand the definition of gun rights in some manner. So we'll see what happens. I think you might be ahead of the curve on this, so I think you should stick with it, see what happens. So yeah, final point there. All this suggests that the federal courts, including some members of the Supreme Court, may be disposed and poised to markedly expand the definition of Second Amendment rights. Now, that's not the focus of my paper. That's just the context, because my paper examines the law, the history, and crime-related issues surrounding ammunition magazines and silencers, which are also referred to as suppressors, because some people don't like the original term silencers, even though that was the term used by the fellow who invented gun silencers. Okay. So let me talk about ammunition magazines. On its face, neither large capacity magazines, so-called LCMs, those generally defined as holding more than 10 rounds, nor silencers are essential to the functioning of firearms. For weapons like assault rifles, capable of receiving magazines, they can be limited to magazines that hold no more than 10 rounds. That was the federal law for 10 years. Alternately, magazines can be fixed in place so that they're not removable. I actually worked with a friend of mine a few years ago, and we did this very thing to the lower receiver of an AR-15 that the two of us built. He was more the expert than me, but it was very interesting. So there are fairly simple ways that you can still have functioning firearms, but by, for example, fixing magazines in place so that they are not detachable or interchangeable. That's actually how New York State law reads right now. And neither impedes the ability to use firearms, that is, their presence or absence. Where do I point to? Oh, okay. So I discovered this interesting fact. You know, we're having this debate about whether large capacity bullet magazines should be regulated or not, and we date this to the early 1990s, late 1980s. But in point of fact, from 1927 to 1934, at least 18 states enacted restrictions on ammunition magazines and/or maximum magazine capacity. And I have the actual table. It's at the end of the presentation. It's kind of hard to read the print. 9 states imposed firing limits on semi and fully automatic guns, ranging, depending on the state, from guns that fired more than 1 round at a time to those set at a max of 18. That is, if you owned a gun, depending on the state, that, let's say, in the case of this state, fired 19 rounds without reloading, that was against state law. You couldn't have it. 5 states applied restrictions to fully automatic weapons only, and of course this is before the 1934, leading up to the 1934 National Firearms Act, which severely regulated fully automatic weapons, Tommy guns, things like that. And a majority of the states had enacted regulations to bar or restrict fully automatic weapons leading up to the 1934 federal law. But the point is, 5 of these states applied restrictions to fully automatic weapons only, but did so by defining the number of rounds that could be fired without reloading or by the ability to receive bullet-feeding devices. And 4 states restricted all firearms. It didn't mention types. It simply said all firearms that could receive any type of bullet-feeding mechanism or feeding device and fire them continuously in a fully automatic manner. So you add those together, and this is a significant number of states that are imposing regulations that are really all about bullet-feeding devices, to sort of state that broadly. Now, contemporary concerns about large capacity magazines. Well, the 6 deadliest mass shootings from 2009 to 2019 involved assault weapons that utilized them. Large capacity magazines were involved in more than half of all firearm mass murders. From 2009 to 2015, LCM mass shootings resulted in more casualties, 155% more people shot, and 47% more deaths than when the perpetrators did not use LCMs. So that's part of the criminological concern. Since 2004, gun crimes committed with LCMs have increased steadily. 2004 was the year that the assault weapons ban lapsed under the terms of the law. It was set to be in force for only 10 years, automatically lapsed. Congress then had the option of renewing it, but it did not. And after that point, the use of such large capacity magazines escalated and continued to escalate. States with bans on LCMs had a 63% lower rate of mass shootings than states without, controlling for other factors. That's from a recent study. And frankly, there's no compelling argument for unfettered civilian access to LCMs. I mean, there's really sort of one argument, which is there are some people who like to go to a shooting range and fire off bunches of rounds without reloading. Because some people find that, fun, a form of entertainment, stress release, things like that. And that's a reason. But of course, you don't see anybody standing in front of a microphone after a mass shooting and saying, well, I think we shouldn't impose restrictions because I like to go to the firing range and fire out, lots and lots of rounds. But the fact is, it's kind of the main reason. Oh, come on. There we go. Now, what about gun silencers? Well, from 1909, and silencers were patented in 1908, to 1934, at least 13 states imposed restrictions on silencers. 6 of these 13 barred them specifically for use in hunting. I mean, stipulated that in their state laws. And as you know, silencers were regulated nationwide in the National Firearms Act of 1934. You can obtain them, of course, just as you could then, but you had a fairly substantial fee of $200, which was a lot more money in 1934 than it is today. ATF background check, fingerprinting, and photographing. And you can see the pictures here. And there's my iconic hero, Homer Simpson there. And Saul Cornell, is he holding a silencer or a loudener?
I think he said that that's a device used to shoot down black helicopters.
Oh, okay. I don't remember that, but anyway. Okay. He's Homer's examining gun accessories. So, it seems relevant, so I included it. Reporting on the demonstration of gun silencers when initially developed and marketed by the inventor Hiram Maxim, who was trying to sell this product to the American military and European military forces, Scientific American had a reporter who wrote a fairly lengthy article about this. And there's just a short excerpt here saying that the menace of silencers in this article that have greatly enlarged the opportunities for the commission of undetected crime. It is well understood that the fear of detection is one of the most powerful deterrents to the commission of crime. And that expressed the concern in 1909 and subsequently. Now, silencers today, you may know that a bill was introduced in Congress 2 years ago in the House of Representatives to deregulate silencers. The name of the bill there, the Hearing Protection Act. That's significant because that was the justification, the reason for deregulating them. That bill didn't proceed very far in the House. Early this year was reintroduced, but in the United States Senate. And both pieces of legislation would drop the NFA requirements, making silencers legal for anyone who could pass a Brady background check. So there is that sort of minimal standard. And silencers are currently legal in 42 states, meaning 8 states bar them. So what are the arguments for and against regulating silencers? Well, the arguments for deregulation to protect the hearing of shooters. I mean, that's the stated purpose of the federal legislation and those who are nearby. They reduce gun recoil, and as many have noted, they are rarely used in crime. Arguments against deregulation. Well, hearing experts actually recommend that you wear hearing protection even if you're using a silencer. Because, of course, they don't eliminate the noise entirely, far from it. They reduce it somewhat, but there are professional societies that, are involved with studying hearing loss and making recommendations and so on. And they say, look, even if you have a silencer, you should put on hearing protection anyway. And in fact, it's more effective than simply putting on a silencer. Moreover, the noise that firearms make is a safety function. And I don't mean to suggest for a minute that somehow guns are produced to be loud. I mean, it's simply a consequence of firing a firearm. But the fact is, whether it's a hunting situation in a sparsely populated area, in a rural area, or in a gun crime situation, the noise of gunfire is the first indication that there's something amiss, that there's something wrong. If you're out running in the woods, if you're walking down the street in a crime-prone neighborhood in a city, and I wrote an article about this a couple years ago. And as for the crime issue, well, crimes have been used, silencers have been used in crime since their invention, and I discuss in the paper, going back to old newspaper accounts, because there are no statistical or systematic analyses of, how many crimes or how many silencers. I mean, nobody gathered that data in the 19-teens and 1920s and 1930s. But it's not hard to find news articles that report on crimes that involved silencers. And clearly they were used in crimes. But that all but disappeared after 1934, suggesting that the 1934 law was pretty effective at doing what it set out to do. Moreover, in the modern era, silencers can be used to defeat what's called shot spotter technology, which I'm sure many of you are aware, particularly in large cities and crime-prone areas, there are sort of detectors that authorities put up, and if they hear firearm, if they hear gunshots, it allows the police to figure out where those shots are being fired and to get to the scene right away. Oh, sorry. So, conclusion. There is a legitimate public interest, public safety concern in restrictions on LCMs and on silencers. Accessories, after all, are not firearms. And for me, Justice Thomas's complaints that the Second Amendment has been treated as a cavalierly disfavored orphan by the courts is without merit or evidence. I think the Heller standard, set in 2008, has struck a roughly reasonable balance between gun laws and gun rights. And finally, thinking ahead, could it be in the not too distant future that the Second Amendment umbrella would be applied to designers, Gucci, Louis Vuitton, even Mo over here? That's Mo, if you didn't know. But these are actual pictures of, there's Gucci right there. You recognize Louis Vuitton. I'm sure all of you have your Louis Vuitton gear at home. Well, I thank you for your kind attention, and Madam Chair, I yield back the balance of my time.
No, you came in perfectly on time.
Sorry. This is that table listing the states in the three categories, and you can see it's a lot of fine print, but it's there, which I just wanted to show you that it's there. So, all right. Thank you.
Right. Well, thank you so much.
I guess we could
just leave it. Okay. Yeah. No, we're getting the cue that it's happening. Thank you. Okay. All right, Jake. Whenever you're ready.
All right. Well, thanks for that, and I regret that my presentation will not be as entertaining as that one. So we've talked a lot today about the interests and values that conflict when firearms leave the home. I want to approach the issue from a slightly different angle and talk not about what happens when guns get outside, but on who can take them there, or in fact on who can own them in the first place. How should we think about these laws that disarm certain classes of people? Should we think about certain people as outside the scope of the Second Amendment altogether, like we think of certain weapons as outside the scope of the Second Amendment? And should we view all classes of people the same for the purposes of answering that question? These questions arise from some conceptual concerns over how courts treat laws that disarm certain people. I'll aim to make 2 points today. First is that we shouldn't just treat people the same as we treat arms and activities at the initial stage of determining the Second Amendment's scope. And second, that despite those good reasons, there are still some classes of people that we can consider completely outside the scope of the Second Amendment altogether. Now, federal law bars nearly a dozen categories of people from possessing firearms. Some of those bars are temporary, such as for people who are using or addicted to a controlled substance. Once the addiction or use ends, so too does the federal bar. But some of the bars are permanent. So, for example, most felons are forbidden from life from ever possessing firearms. So too are those who have been adjudicated mentally ill or who have been committed to a mental institution. Some states have added additional categories such as violent misdemeanors or those who abuse alcohol. And earlier this year, Seventh Circuit Judge Amy Coney Barrett described two possible views of these types of prohibited person laws. The first view, she said, maintains that there are certain people, like violent felons, say, who fall completely outside the scope of the Second Amendment. The second view is that all people have the right to keep and bear arms, but that history and tradition support the government's right to strip it from some people. The debate Judge Barrett described centers on how to think about these prohibited people's Second Amendment rights. Are their rights non-existent or just defeasible? Or to put it in contract terms, are their rights void or voidable? Answering this question requires us to choose between step one or step two of the two-step framework that's become the standard in Second Amendment litigation. The first step asks a coverage question. Are arms, activities, or people within the scope of the right? If they are not, then the regulation is upheld and the government wins. If they are, then courts move on to the second step and ask a protection question. Has the government met its required burden under the appropriate means and scrutiny? This two-step coverage protection framework is the type of inquiry that's nearly unavoidable in constitutional adjudication. For example, there are some types of speech that are just not speech for purposes of the First Amendment. As we discussed earlier, securities fraud, perjury, these are not types of speech that are speech under the First Amendment. So too there are types of weapons that are not arms for purposes of the Second Amendment. Flamethrowers and suitcase nukes might be bearable arms, but courts are going to kick those out at step one. They're not covered at all. Judge Barrett argues that we shouldn't treat people like arms or activities. On her view, we ought to move straight to the protection inquiry and consider everyone as covered. The opposite view, adopted by courts like the DC and Ninth Circuits, says we should actually just treat people the same as arms and activities. These courts have held, for example, that felons fall completely outside the scope of the Second Amendment altogether. Judge Barrett notices something odd about these views. For instance, on this view, a felon or a class of persons could be covered by the Second Amendment and uncovered by the Second Amendment a day later. If a person gets convicted of a qualifying offense, they would automatically fall outside the scope of the Second Amendment. No government action would be needed to strip them of the right. It would be a self-executing consequence of the conviction. Arms and activities, on the other hand, are often thought about in more static terms. They don't change status day by day. We think of suitcase nukes as always being out, for example. That's why Judge Barrett says we should view person-based prohibitions as protection questions only. As she says, all people are covered. A person convicted of a qualifying crime does not automatically lose his right to keep and bear arms, but becomes, quote, eligible to lose that. Now, one could think this makes an important insight, but perhaps overstates the distinction between arms, activities, and people. Heller, for example, told us to ask a question about arms that seems like a coverage issue. For example, are they in common use? So there could be arms, for instance, that were out, not in common use decades ago, that may be in common use today. So they may have been uncovered previously and covered now. The reverse we could also imagine might be true. For example, if revolvers fall out of common use, might they lose their constitutional coverage? But Judge Barrett is surely right that it's peculiar to think about people in such dynamic terms, that whether they are inside or outside the scope depends on a self-executing status determination. And it's not how we view other constitutional rights either. And the 14th Amendment tells us that states can permissibly disenfranchise felons. But if a state does not pass a law to disenfranchise felons, then felons have their right to vote fully intact, and they can go to court to enforce that right. In other words, felons are universally recognized as covered by the constitutional right to vote. They're inside the scope. But with respect to the right to keep and bear arms, the view of the DC and Ninth Circuits would treat this same group of people much differently. What this view would mean is that even if no positive law barred felons from possessing firearms, they would have no right to go into court, no standing, to challenge other firearms restrictions, like regulations on high-capacity magazines or on what it takes to obtain a concealed carry permit. Because on this view, the constitutional right doesn't extend to these people at all. Their privilege to own guns would exist solely as a matter of legislative forbearance and not as a matter of constitutional certainty. So this anomaly gives us at least some reason to think that we should treat people-based prohibitions differently than we treat arms and activities. Why would person-based prohibitions for one constitutional right be coverage questions and for another be protection questions, even for the same group of people? But those reasons also don't justify treating all person-based prohibitions the same and simply moving to the protection inquiry for everyone claiming a right to own a gun. For example, few think that toddlers or those unlawfully residing in the United States can invoke the Constitution's right to vote. Those are coverage issues. We think of some people as simply outside the scope. Again, so to me, that seems the same with respect to the right to keep and bear arms. There are some classes of people that are simply outside the scope. Again, minors come to mind, though there might be questions about the age of majority. Consider also the language of the Second Amendment, the right of the people to keep and bear arms. The Heller majority appears to have read this phrase narrowly, to apply to citizens, and not just to citizens, but to law-abiding and perhaps separately responsible ones. As Justice Stevens noted in dissent, the court itself reads the Second Amendment to protect a subset significantly narrower than the class of people that are protected by the First and Fourth Amendments. When it finally drills down on the substantive meaning of the Second Amendment, the court limits the protected class to law-abiding, responsible citizens. The upshot, then, is that Judge Barrett's important insight identifies an anomaly in how some Second Amendment challenges are adjudicated. But that doesn't mean we should treat all people-based questions as protection questions. Some can and should be decided at the coverage stage. And one way to distinguish between which categories we should treat at the coverage stage and which at the protection stage is to leverage Frederick Schauer's notions of defining out versus defining in for coverage questions for constitutional rights. On the defining in method, we construct a theory about the underlying purpose or goals of a constitutional right and define in those people or conduct who fit within that theory. This requires a fairly specific and at least moderately well-settled version of what the right is for. It focuses on the positive. Do we have reason to include this person or conduct? On the other hand, the defining out method starts out more ecumenical. It takes what Schauer calls an intentionally broad and coarse view of what the right is for and defines out those individuals or conduct for which we have no good reason to grant coverage. The defining out view errs on the side of over-inclusiveness. We exclude things from coverage only if we find there's no good reason to grant them protection from the power of the government. And for that, the onus is on those arguing for a lack of coverage. For example, in the Second Amendment, we lack a widely agreed upon theory of the right's purposes and goals. Competing views point in different directions, making the defining in view likely to appeal only to those who adopt an underlying theory in the first place. By contrast, the defining out view might take a coarse and intentionally overbroad view of what the Second Amendment is for, say that it covers all arms bearing for lawful purposes. Rather than define in those persons or conduct who fit a specific theory, we would define out those for whom there's no good reason to grant coverage. On the defining out view, again, the burden is on those arguing for lack of coverage. Consider again the question, do second graders have Second Amendment rights? To put it in Judge Barrett's terms, Heller says the Second Amendment protects all Americans and children are Americans. Despite some intuitive appeal, we don't have particularly good reasons to protect children. They typically won't have a great need for armed self-defense. Teachers, guardians, and parents are often required to maintain and ensure their welfare. They weren't allowed to serve in the early militias and are not allowed to serve in the military today, so they won't help advance the cause of national security. And due to their fragility, immaturity, and youth, they won't make great compatriots in a fight against government tyranny. Since we have no good reason to grant coverage, we can define them out. They can thus be considered outside the scope of the right. This way of thinking about prohibited persons puts the burdens on those who would exclude coverage, but it doesn't, like Judge Barrett's view, make all people-based questions ones of protection. Sometimes the burden is met, like for small children, and we can exclude them out altogether. Query whether the same is true for the class of non-citizens, or even a smaller subset like those unlawfully residing in the United States. Courts have split on this question. Some have said they are outside the scope of the right altogether. Others hold or assume they fall within the scope, but find that the government can nonetheless permissibly dispossess them. To resolve that split, court should test whether those arguing against coverage have met their burden to define out this class of people. I've tried to show here how person-based prohibitions are multifaceted and complex. On the one hand, we shouldn't just treat classes of people the same as we treat arms and activities. People are differently situated. At the same time, that doesn't require us to treat all people-based prohibitions as protection inquiries and move straight to the second step without considering whether this person is within the scope at all. Some, like small children, are just outside the scope. We can use the defining out method to distinguish between these two different person-based claims. That puts the onus on those who would exclude from coverage and thus likely moves more claims into the protection stage. And that, I'd argue, is how it's supposed to be for a constitutional right. Thank you.
Great. All right, well, thank you so much. And we do have some time for questions, so I will start by posing a couple. So first, Brannon, I want to start with you. I thought a fascinating presentation, and you had kept me in suspense about what you're going to talk about, so I was not disappointed. And it was also a great segue from the first panel, obviously, because we have rights in conflict, and here we have rights, in combination. And so, as I understand it, you're suggesting that there is some value in an analysis in which courts undertake to evaluate rights and interests in combination or in tandem or in using some kind of hybrid rights analysis. So I guess I have two questions. One is that as a descriptive or a normative matter how constitutional rights evaluation works, right? So you mentioned a bunch of cases, many of which I haven't read in some time, but Obergefell I have read recently, and you even did express a little skepticism as you invoked Obergefell, but I would agree with what I took to be your skepticism, which is that the equal protection and due process arguments in Obergefell are inextricably interlinked, but it is not as though you have an insufficient due process argument or interest and an insufficient equal protection interest that you aggregate and get a plausible or winning claim, right? That's just, typically, and I think this is true about the earlier cases you invoke, you have a standalone winning constitutional claim that is informed by other kinds of interests or considerations. And so it's not quite additive. And so I guess if that's the case, then we can think, we can gain some understanding about the nature or scope of the interest by the other constitutional provisions or values that it invokes or is informed by. But is it really a hybrid kind of analysis as you're suggesting? So I guess that's question one. And question two, which actually takes as a given that there is some real value in this mode of analysis, and asks whether it might be worth thinking about aggregating interest in the way that you're suggesting on the regulatory side of the balance. So, and it's not, maybe it's a move that courts have made, but I haven't seen it much. But so New York invokes, as of course, lots of governments doing this kind of regulation do health and safety in the case that you're describing. We have, various versions of some kind of First Amendment interest, a potential chilling, a bystander sort of Eric style analysis. And, as you were talking about the right to travel, I was thinking, is there a right to travel interest we could think about or imagine on the pro-regulatory side of the balance? But if this is a valuable or fruitful mode of analysis, is it one that should be deployed kind of on both sides of the balance?
Those are great questions, and I think they're related to the question that I don't have a good answer to, which is when is it appropriate to disaggregate and when is it appropriate to combine, and what sort of factors figure into that. Now, on the first one, as a descriptive matter, it's possible that this hybrid rights analysis is indeed just a make weight, and that in cases like Obergefell, it would have been easy for the court to rely on one or the other, either due process or equal protection. But that simply raises the question: why does the court feel compelled in some of these cases to appeal to both? Why do they act as if this hybrid rights thing matters? There's a sort of belts and suspenders thing that helps shore up the legitimacy of tenable but not clearly established constitutional claims. And I think that's what's going on in some of those cases. I mean, when you read those early 70s or those 70s, 80s right to travel cases, sort of when the kind of heady days of Frank Michelman and we're going to use the equal protection clause to protect poor people. They clearly weren't willing to describe wealth as a suspect class, but it was often convenient to use the right to travel married with the equal protection clause in order to say, okay, well, here we're creating classes of people who are newcomers to the state, and you're trying to exclude them from certain sorts of public benefits. That's not what we're about. But you could tell that there was a sort of tentativeness to the court was only willing to go so far, down that road, and of course then retreated completely. On the issue of aggregation on the regulatory side, I mean, there are other types of clausal combinations that sort of bolster governmental power. So And Michael Coonan has a great article about this in the Penn Law Review from a couple of years ago. And if you're interested in this at all, I highly recommend it. I mean, Michael's a fantastic scholar, and this article is a real gem. I can't say enough good things about it, and it was what got me thinking about, sort of rescuing me from my otherwise very jejuned approach to the case. Michael talks about, he said, well, hybrid rights are only one type of constitutional combination. They're power combinations too, McCulloch v. Maryland being one. Justice Breyer's dissent in the copyright extension case, where he says, look, all these sorts of powers operate to, we ought to think about that as limiting, or in other words, power combinations would tend to expand governmental power when powers individually standing alone may not produce the effect that was desired. So I haven't thought about if you aggregate interests on the other side, but I kind of wonder whether we don't already do that. I mean, because it goes to the strength of the strength of the government's interest in, the strength of the government's end, or the importance or compelling nature of the government's end, I would guess.
And so maybe I'll just ask one more quick one in the interest of time. And so this is for Bob. I wanted to ask you, well, one, I wanted to just flag something that I think you didn't really mention in the presentation, but that you draw, so this is like me a little bit carrying water for the center, but you draw in the paper on this wonderful repository of historical gun laws. And I'm sorry, I did not know that this existed, and I'm sorry I didn't, but it seems like a tremendous resource. And so I just wanted to flag that seems like a really central piece of the paper. And so that's one. And then two, it's something else that I thought was fascinating. I am always really interested in the kind of relationship between rhetoric and law, politics and law in this sphere. And you have this wonderful little section in the paper about the kind of evolution and the sort of the valence of the term assault weapons. And I just thought I did not know about this history. And I was just going to ask you to sort of describe briefly, and I don't know if you want to speak at all as to how what you've uncovered on assault weapons in particular as a historical matter might bear on courts' evaluation in the future, future challenges. But I just wanted to give you an opportunity to talk about those two things if you have, for a minute or two.
Yeah, that's great. There's much rhetoric which says that the term assault rifle, to focus on that term, was invented by gun control advocates in the late 1980s to sort of put a scary label on these types of weapons to encourage their regulation or restriction. But there are two important facts about that. The first is that the term was not invented by gun control advocates. It in fact came first from the manufacturers, but secondly, more importantly, by the civilian manufacturing companies that made these things that tried to then peddle them, sell them to the public. And a chief advertising technique was to emphasize their military derivation, their military resemblance, that it's just like the battlefield, and this was central to their whole advertising campaign. But then along comes, people starting to use these weapons in mass shootings, and so there's now sort of this stigma, and so the gun manufacturers and the sort of political side, the NRA, are beginning to argue, well, no, they're sporting weapons, and insisted that they be referred to that way to avoid the invidious term of assault rifle and the military derivations. But of course, it was developed for use by the military in the late 1950s. The weapon came to be in use by the military in the 1960s. It didn't really enter, it was available to civilians into the 1970s and the early 80s, but very few gun owners bought these weapons. There was really no interest. They were kind of expensive, sort of exotic. But then in the mid to late 1980s, China dumps a bunch of these weapons, SKS-type weapons, on the American market. They were sort of military surplus at a cheap price, and they're now less expensive. People start to buy them, and then they're marketed pretty aggressively by the gun manufacturers, partly because there's kind of a high markup on them. There's more of a profit to be made from these weapons. They're more expensive. They have accessories. You can make money off the sale of gun accessories. They've been referred to as Barbie dolls for men. You buy the Barbie doll, you buy the dream house, you buy the Barbie car. Anybody? Okay, maybe. All right. Sorry. I revealed too much, perhaps. But I did have daughters, so that's my excuse. And, the same idea with assault weapons, and the owners will kind of tell you these things. They love the accessories, interchangeable parts. That's fine, but sort of like a tricked-out pickup truck has a much higher markup than a subcompact. The margin of profit is bigger for the more expensive, more fancy motor vehicle, and the same kind of thing applies for assault weapons as well. So, I mean, the chief difference is, of course, that these weapons available to civilians fire only in semi-automatic fashion. They don't fire fully automatically, although, as has been often noted, there are ways you can alter weapons to do that. And military weapons also have had the capability to fire in short bursts, normally 3-round bursts. So you're altering the firing mechanism, but the weapon is basically the same. And for all of the emphasis on what are sometimes called cosmetic features, which is a fair criticism, like a threaded barrel that can receive a grenade launcher, let's say. I mean, that's not really. I mean, that's a military attribute of these weapons, but it's not really an important aspect of their availability in the civilian market. But what is important is the ability to receive large capacity magazines. That really, among the so-called military features, that's the one that really matters. And that brings into play the whole question about bullet magazines. So I talked about the kind of assault weapon story a little bit, just because I think it's not real well known, and it's useful to get to the subject of magazines.
Thank you.
Sure.
Okay, so I want to make sure we have time for a couple of questions. There's a microphone in the back if we can pass it. Or if you don't mind just grabbing the mic so we can catch the recording. It's right back there. Thank you so much. Yeah, please, in the back with the white shirt. Yeah.
I think you got to turn it on. Maybe push that little button up.
Hello.
Can you hear me?
Yes.
My name is Manal. I'm from Lebanon. I'm from the Public Policy Department across the street. Thank you for this wonderful symposium, I guess. Really very, very helpful for me as I think through thesis topics. I'm specifically considering looking at small arms and light weapons production of the US and its export around the world. And I wonder if you have any advice for me as I look through licensing and regulation around these issues. If you would point me to specific articles, authors, if you could speak about this at all today. Thank you.
Well, some of that we should probably take offline because we're going to go to lunch soon. So I would say like specific references, I think people could probably give you offline. But if anybody wants to respond more generally to the question.
You're talking about
like
American sale of
export.
arms or export.
Yeah.
Yep. It's the largest around the world. Well, exports and imports are valued at more than $500 million.
America is the world's largest exporter of arms, and the Trump administration has deregulated that to some degree. There is writing on that for sure. I couldn't tell you. I can't be helpful, I'm afraid, in that regard. But it should be pretty easily accessible. Yeah, and of course, gun manufacturers are very interested in that market because they want to sell their product.
Thank you.
I suspect that there's a high density of expertise in this room, so I think if you stick around, please, anyone who knows anything about this, come find.
Thank you.
Wait, what's your name again, sorry?
Manal,
Manal, okay,
like
so.
canal, that's my little trick.
Like canal, okay, great, so please come find Manal during the break. Yes, please. Joyce, right, yeah.
Oops, heavy, yeah, thank you. I have a question for Brannon. Thinking about the New York case and the emphasis on being able to protect yourself in your home, there are only 40,000 people in the city of 8.5 million in New York who have a right to have a gun in their home. And I wonder whether or how that has come about. Do you have any sense of that?
I mean, I would assume that it's a function of two things. I mean, I don't know what the percentage of people who have applied for premises licenses unsuccessfully is. But it has everything to do with the discretionary power that the chief of police or his or her designee have in deciding who gets those licenses. But I don't know what the rejection rate is. I don't have a sense of what that is. And it may be just that again, it's maybe sort of a cultural thing that New Yorkers maybe people don't apply. Maybe they don't know that they could apply for a premises license, or maybe they just don't feel like they want one, but I don't have a good sense of, whether it's something that is that's in demand that is being restricted.
Hey, thank you very much for coming here to Duke. This is really exciting to have such a robust conversation. My name is Mason Rogers, and I have a strong interest in the First Amendment, specifically the freedom of religion. And there's a group in Pennsylvania who, there's this guy, Sean Moon. He's the son of the Moonies from all those big weddings and everything. He is Harvard educated in religion, and he's asserting that, and this kind of goes to that culture of fear, that in order to maintain his own personal sovereignty and the whole group as a whole, they have to kind of worship the AR-15. This is a real thing. He's interpreting it to be like the iron rod in the Bible, and I'm just curious, like, how those two rights go together. He's asserting Second Amendment rights based on freedom of religion, I think, and it's kind of scary. I don't know whether to be afraid of him or think he's crazy or what, but does anyone have a stab on if Pennsylvania were to limit assault weapons, would they have grounds for freedom of religion?
Is it combined, right?
It's reminiscent of it's been years and years for me, but I remember the snake handling and peyote cases based on religion, right? Which would be relevant to this, I would think, but I've not heard. You're talking the Unification Church, right?
No, he's actually split. He and his mother have had a big falling out. Yeah, it's the craziest thing.
This guy, okay.
He has his own podcast and everything. He's crazy, but this guy is asserting that it's a key part of his religion. They have these AR-15s in church, and it's like this whole cult that they say, no, we're just a regular Christian religion. But they're all sitting in church with AR-15s. It's crazy.
But it's not doctrine of the Unification Church.
No, it's doctrine.
So it's this sort of break off.
Church.
It's
a whole new thing that he started.
Okay.
Brandon, do you want to continue?
I mean, as a general proposition, generally applicable neutral regulations that incidentally burden religious conduct are perfectly fine, subject only to a rational basis test. So he wouldn't get, there wouldn't be, it wouldn't matter whether, he was a Pastafarian or whatever, those kinds of neutral restrictions are perfectly okay. And I don't think he would get any additional traction by saying, well, this combines my Second Amendment right with my free exercise clause, with my, I don't get a sense that would
Why is that
find
not
much
different
purchase.
than traveling with a gun?
Well, now, in terms of
those values.
Well, again, that gets back to it gets back to the when do you combine question, and I don't have a good answer for why I think that combination is ridiculous and mine is eminently sensible, other than the fact that the latter is mine. So points for candor.
All right, well, Joseph's going to get the host prerogative to ask the last question.
Grab them.
Not at all.
I just have one question, Bob, which I think is in the four corners of your paper, which is it's just been I've been puzzling through since the presentation, which is how you think about the sometimes criticism of assault weapons restrictions in particular, holding aside large capacity magazines and silencers, which is the definitional problem key to those cosmetic features you were just talking about. And I heard, I think, sort of two answers to the criticism in what you said. One is these aren't just cosmetic features. Those criticisms are wrong, that at least with the capacity to accept a high, detachable magazines, that's actually functional. So the cosmetic feature thing is wrong. Maybe that's less true for telescoping stocks and barrel shrouds and other ways they've been defined. But the other response I think I heard or read in the paper is that those are cosmetic features, and that's why it's not a problem for the Second Amendment. That these are just regulations of cosmetic features, and if that's true, it should have no impact on anybody's self-defense rights one way or the other. And I wonder if both those things are true, or if you can have both those things be true, but it's a hard thing I think, for the definitional project.
Yeah. In the way you've described that, it does, there is a simple logic then to saying, look, if they are simply cosmetic or incidental, why would there be an objection to sort of restricting those things? But the thing is, that's sort of conflated with the larger debate about what is it about this type of weapon that distinguishes it from other long guns that fire same rounds, that fire in a semi-automatic fashion. And the first effort at regulation was, back 20-something years ago, and they, defined in the 1994 assault weapons ban, they defined those weapons as having at least two features, and there were, barrel shrouds and threaded barrels and collapsible stocks and things like that. But there is one additional firing characteristic that is relevant, which is, aside from the ability to receive large capacity magazines, which is the ability to have the kind of greater kind of control over the weapon that on the battlefield allows you to lay down spray fire. That is to say, because it's more compact, because of sort of the hand grips and other things, it facilitates the firing of rounds in sort of a spray fire manner. And so some of those features do come into play in that respect. And so in that sense, those things are not purely cosmetic. So there's kind of the convergence of these two sort of views of how the weapon is to be treated.
All right, well, thank you so much to the panel, everyone. It's been great.